This Mr. Sealing?
Yes, Your Honor. He also has an open felony. He'll be back on your bond hearing calendar.
Okay.
Excuse me, sir. I don't want anyone to represent me, and I'd like to speak for myself.
Right out the gate, this is a status conference. Think of it as a court's progress check. But in this case, progress seems to be moving at the speed of a stalled shopping cart.
So right now, the public defender is appointed to represent you at this
No,
time.
I did not sign any papers for any public defendant to address me. I have the right to represent myself. That is the Sixth Amendment. I know the law, and I'm here to address the law. I would like the same respect as the public defender, as a prosecutor, and I would like my knowledge of the law to be acknowledged. Did you read the A form yet, or
No, we're not here on the felony. We're just here on the traffic citation.
a traffic citation?
Yes.
Okay, so we could adjust that. So I went to I had a text.
Sir. I understand that you want to represent yourself, but representing yourself can
Yes, I represent myself.
Sir, there's a lot of potholes and everything that you could be falling into by trying to represent yourself. I'm gonna give you advice that you should remain silent. I understand that you do have felony cases for it. I understand everything that you're saying here right now is being recorded.
Yes, I'm aware.
I understand, but so you have the right to remain silent, and anything you say is being recorded.
And I do have the right to be heard as well.
Well, I have not gone over.
I'm fully aware of the law, and I'd just like to speak.
Sure.
You said we're going to adjust this bench warrant. Now let me adjust the bench warrant. Can I do that?
Look, I have not gone over the criteria of whether or not you are competent enough to represent yourself. This is just really a bond hearing, generally. But if you don't want the public defender to speak on your behalf, then
is it not the Sixth Amendment for me to right to represent myself? I'm just trying to speak and represent myself. That's all. Can you allow me to do that, please, Your Honor? I know the law. I studied the law because my rights were violated, and I didn't like that.
Wait, what do we have here in this case?
It's on warrant for disobeying police, fire, and I'm assuming the total bond amount would be $3,000.
Is that the standard bond for this, or is this part of
This could be the total bond.
Hey, can you speak in the mic, please?
This could be the total bond for his all, including his felonies. Could be $3,000.
Failing to appear for his jury trial.
Okay, so then it would be $3,000 for the disobeying the fire police bench warrant.
Okay, so
All
may
right.
I speak now, please?
Certainly, sir.
What did you say?
I said certainly. Go speak if you wish.
So I woke up in the morning saying that I had a bench warrant text. I called the judge's chambers and I went on Zoom. They did not let me in the Zoom. They did not let me in the courtroom. Then I had a confrontation with the police officers while I was getting food at a Jamaican spot. They said that I had a warrant. Please, can you please not interrupt me? Okay, so boom, I had a confrontation with the police officers at a Jamaican spot where they said that I had to leave, and they said ask me for my ID. They seen that there was a bench warrant, and they arrested me for this same bench warrant. Then I explained to the judge what had happened, and they do have record that I attempted to go to the courtroom, that I attempted to go in the Zoom, and they just didn't let me in. So the judge RR'd me based on that information. Do you have that same information that I did attempt to go here and I'd already got arrested for the same bench warrant?
Her attorney's frustration is showing. When a lawyer starts using words like non-compliance in open court, it's a polite way of saying, we're done playing nice.
So no, I don't have that information, sir.
So
hold on. Let me ask the state. Maybe the state has that information. State, do you have any information?
Not at this time. And
they don't have an arrest record of me being arrested for this bench warrant already?
We have your arrest date being yesterday for this bench warrant.
No, there was arrested. I got arrested, and I was out on pretrial for this bench warrant. I'm not sure what's the issue is. This was documented as well. I was in misdemeanor court. This was also documented, and I was on camera in the courtroom on last week Friday, or the other Friday or whatever when this issue happened. I was in the courtroom on camera. And I was in a Zoom, so I have proof that I actually showed up, and I still got arrested. And now they're saying that this bench warrant is still open. Can you guys investigate this, please? And
We
like,
have
Hold on for a
we
second.
have on July 29th, you failed to appear for your jury trial, and a bench warrant was issued and has not been set aside yet. So no judge has, if you did appear, no judge has set aside your bench warrant.
and why did no judge? Because I had court. I had court with the judge, Carrera. Someone was replacing Carrera at that date that I had court, and I explained fully in detail with that judge that was replacing Judge Carrera exactly what happened, and he said that I will get a new court date in court and to call the court after a week. So this is all documented. The same way this court appearance is recorded, that court appearance was recorded. The fact that he rescheduled me. Why did he reschedule me instead of uplifting the bench warrant after I already adjusted it? I actually tried to attempt to go to the court, and I even went on Zoom. I have a screenshot on my phone, and I got arrested for the bench warrant, and I adjusted it with 2 different judges. So it's like, what's the problem? What can y'all find this evidence? Because it's on a recorded courtroom. I
Even
talked to
if you
2 judges
All
about
right,
this.
all right, hold on. State,
Okay.
you have any additional information?
Even if you did speak to judges, they did not quash the warrant. So
And why is that? I'm liable to be arrested. Okay, I'll listen. I'll listen.
Well, what I'm saying is that the state, his officers of court are saying they don't have any information that this warrant that was issued on July 29th, a couple weeks ago, has ever been set aside or quashed by any courts.
Do you have any evidence of me actually having court? That's what they're saying.
No, I don't have any evidence. This is just a bond hearing, sir.
So why did I get released for pretrial on a bench warrant?
Here's the thing, family court deadlines aren't soft guidelines. They are hard stops. Miss them, and the other side can and will weaponize it.
Corrections,
The public
do
defender's
you
office
have
can know this
uh,
as well, because I called the public defender's office. I called the judges' chambers, judges you Bastando, Judge Carreras, Rivera, judges' chambers. I even logged in on a Zoom, took screenshots.
Well, you have a
Like,
representative of the
I'm trying
public
to go in the courtroom, and I even got arrested for the bench warrant already, and then you guys have recorded court. Like, what's going on here? Because I already got arrested for this bench warrant, and you guys, I'm literally on the same camera with the female judge. She gave me pre-trial for this bench warrant because I already attempted to go in the courtroom, and I had record of this.
All right, so this is just a bond hearing. I'm sure there'll be a lot other court hearings that
bond
will
hearing,
come,
yes. And
that which you'll be able to explain and get your evidence.
Okay, so what I'm saying is the felony charges. So that is against the equal protection rights. So that all those charges needs to be dismissed, because
All right,
if
well,
they
I'm not dismissing any charges today.
okay, well, may I have ROR? May I
Sir?
explain to you how they violated my rights?
No,
Because you have that right.
Not today. So I'm gonna I'm gonna leave the bench warrant on for that case. For 3,000, and then when your felony case comes back up, I'll look at those charges at that time.
But I have bond arraignment for the felony case, right?
I'm not sure. I don't have the felony case in front of me yet.
Um,
They're gonna bring it up in a few more minutes.
in a few more minutes.
Yes.
Okay.
Okay, so with the bench warrant, can you please give me a pre-trial RR like the last judge, because there still be no reason why
Let me
I'm having to pay if I already went in there.
Well, let me see what the attorneys are saying on the felony case when they come to address it. Again, you talked about a public defender. You do have one present, but you're saying you don't want them to represent you. So if you don't allow them to say anything, then maybe I won't know what happened. So maybe they can help you out. Why don't you give them a minute?
Record of me
Sir?
in the courtroom or me being arrested, because I was on the same camera.
All right, but give her time.
I was asking her. I was just
Sir,
asking her.
But you got to give her time. She's been standing here. She's been here all morning.
Yeah, I know.
On so many other cases. So
I know. She
now,
never seen me.
before your felony case gets called, we'll take a break, and maybe she'll do some looking for you, and she may have some more information at that
Okay,
time.
so once you guys do find the evidence that I did go to court, you're gonna give me pre-trial?
I'm not making any promises, but I'm
All right.
saying you at least have the time to look at it.
Thank you. I understand.
All right, sir.
A few minutes, right? So a few minutes, and then we go to
Just a
felony?
few more
Okay.
minutes, and I'm gonna keep the public defender on your case.
Did you catch that? The judge just hinted that if they don't wrap this up soon, she'll make the decisions for them. And trust me, Nobody wants to give up that control.
The case of Donald Armstrong.
Refuse court. Reset for tomorrow, Judge.
All right, but the court is still going to find probable cause based upon the A form. We'll deal with the issue of bond tomorrow then. All right, I've read the A forms, sir.
All right. So I would like to tell you that I own a clothing brand. I just did a photo shoot. Now, before you stop me, I just did a photo shoot Tuesday for my clothing brand. Wednesday, I just did a
why is that?
commercial.
But that's, we need to focus on.
If you listen,
that's the
yes,
charge.
if you
So
listen
I
to
don't
what
have, I don't have all day, sir. We
Yes,
just
yes.
don't
If you
go
listen to what
through-
I'm saying, if you listen to what I'm saying, then you'll understand how everything is put into place. So I just did a commercial and a photo shoot for my clothing brand Tuesday and Thursday. Friday, I get arrested. Now, what I'm saying is, okay, so boom. What I'm saying is that the reason why I've been mentioning the clothing brand because I had money on me. The money was before me selling my clothes on the street. I even had 2 products in my pocket. The 2 products is listed on my website. I have orders to fulfill. I'm the only one that's working my business as well. The products was in my right pocket as well, and it was never mentioned. However, it's in my pocket. I was on my way to go drop it off. I have orders, so people buy T-shirts from me. People buy gym suits from me. Sometimes they pay cash, and I can show you, have proof of that inventory and everything, just in case you want to try to label my hard-earned money as drug money, because I do have a registered business. I do have a website for that business as well, and I have been fulfilling orders as well for that business. With that being said, so
The tension here is more than just legal. It's personal. This isn't just about assets or paperwork. It's about pride, power, and who gets the final word.
what I want to address is that this is not the first altercation with these 2 police officers as well, and this is selective enforcement. And also, because if you like, I would address the other 2 incidents. This officer Dominguez had walked past me on Ocean Drive, saying that thank you for the tip. Now, whole time I never spoke to this officer, never approached this officer ever. So then I walked back to this officer and then put my camera on his face and said, "What tip did I give you? I didn't give you any tip." While he was talking to other officers. Now, boom, I was followed.
Sir, you're
Yeah.
getting beyond what I need to do today. All I need to do
Okay,
today
all right.
is
So let me ask you
determine
this:
whether or not
we
there
can go
was
straight forward.
hold
Do you
on.
have for Bob? Do you
Sir.
find probable cause?
You haven't finished speaking, so I can give the state an opportunity to make their argument. But you started talking about the incident, okay, but then you started going further and further out.
Yes,
which is
because
not
I'm
gonna be
explaining that
relevant.
they have personal
Sir.
vendetta, and this was selective enforcement as well, and I could explain that in detail. But if you
Right,
want,
but we don't have the time for that.
all right,
That would
so
be a
let's
defense
get
that you'd
straight
have.
to it. Do you find probable cause?
All
If
right.
you find probable cause, then I'll tell you the laws that they broke, and specifically.
All right, hold on. State,
All
what do you want to say?
Yes, Your Honor.
And there it is. The judge sets a final deadline. In court terms, that's the equivalent of saying, get it together, or I will do it for you.
In the 4 corners of the arrest affidavit, the state would see that there has been probable cause for all crimes charged in this case. If Your Honor were to start with count 1, which is the sale of cannabis, on the 2nd page, 3rd paragraph, it will show clearly where the officers indicated their probable cause for that charge, saying that he had a wad of cash on him, also combined with the currency combined with the packaging of the marijuana is consistent with street level sales of cannabis. So that would be charge 1. The tampering with physical evidence, it indicates on page 1 going into page 2 that the defendant dropped the marijuana cigarette into a storm drain. And for count 3, possession of more than 20 grams. And on the 2nd page, 3rd paragraph, there were 17 individually packaged Ziploc baggies containing a green leafy substance, the total weight of approximately 132.4 grams. And the state believes that, lastly, count 4, which is indicated on the 4th paragraph, the 4th paragraph, he was within 1,000 feet of Loomis Park. Therefore, as per the arrest affidavit, it appears that all that probable cause is shown for all charges.
May I state my argument now?
Judge,
I thought you already made your argument.
the
No,
public defender.
I asked if you have probable cause, and if you had probable cause, then I explained to you the laws specifically that the police officers violated.
All right. I am finding probable cause as to
And what is the probable
Towns.
cause, so I can explain this? Because
Sir, I find
Yeah.
probable cause that you have committed the crimes in which they allege that they.
what is the okay? So based on the smell of marijuana, you cannot find probable cause because they sell weed in the store. So if I could legally purchase marijuana in the store, then I could legally smell like marijuana on private property. Now, what I'm saying is this A-form said that he said he spotted me smoking a marijuana cigarette, right? So how did he spot me 50 feet away? He was at a red light on 10th and Collins, at a red light going westbound. I was 20 feet away from the corner northbound on Collins when he seen me smoking. So if he seen me smoking, right, and it was almost done, if he seen me smoking, how does he know what I was smoking? And what gave him that right to come in and conduct an investigation? They have tobacco being rolled on Ocean Drive. So now, if they could smoke the tobacco on Ocean Drive freely without listen, without the police grabbing them and arresting them, then I can smoke my tobacco freely because it was tobacco, and I said to the officer that it was tobacco, and he has no proof that it was any type of weed at all, nor can he find any proof. And based on that, based on the fruit of the poisonous tree doctrine, it is illegal to use any illegally obtained evidence against me and against on the exclusionary rule. So any illegally obtained evidence used against me cannot be used against me in a court of law. So all that they found cannot be used against me at all because he wrongfully searched me. He violated my due process by grabbing me. He violated my rights. He violated my rights. Why did he grab me instead of approaching me? And all that time, I already dropped it because it was done. I was done smoking my tobacco. So I had every right to drop it. It's not tampering with evidence if I was done smoking it. And it's tobacco. And he can't see through a tobacco leaf. He doesn't have X-ray vision to say, okay.
All right, sir. You can file your motion to suppress the evidence if they ultimately charge you.
But what I'm saying is,
if they charge you
okay
with these crimes, and then you can file your motion to suppress. You can file. All I'm doing today is determining whether there was probable cause.
And I explained to you that they can't find probable cause.
Right, but I'm presuming what the officers say is correct, and I do find that there is probable cause.
It's his word against mine. How is probable cause? Okay, so boom.
Sir,
do you know what the equal protection rights is?
Sir.
Yeah.
My job to make those decisions. They're not easy ones, but you have other chances to argue them. Okay?
Do you know what the equal protection rights is?
Sir, we're not here talking about equal protection. We're talking about probable cause.
Because if my rights were violated, then I have the right by 6th Amendment. I have the right to address that. I'm addressing that now that the police violated my rights. So
but if your federal right, that would have to be filed. You'd have to file it in federal court. You'd have to file it in
What I'm saying is, the police violated my rights by approaching me something when he never even knew what I was smoking. Why did he approach me instead of anyone else? He was 50 feet away. The A-form, they clearly said that he spotted me smoking a marijuana cigarette. How did he know whether it was marijuana or tobacco 50 feet away? You can't find probable cause for that. He can't smell 50 feet away at all. And even if you want to say smell marijuana, I can legally purchase marijuana.
I have found the probable cause. We're now going to set the bond. You will have your opportunity to make those arguments to the division judge or to a jury when your case ever gets filed.
Letting you know by the law.
Your Honor, if the state may give their suggestions for the bond amount,
yes,
the state would be asking in counts 1 through 4 to set a bond of $2,500, and counts 5 and 6, the state is fine with standard of $500 and $150.
So it's saying for count 1, $2,500, count 2, $2,500, count 3, $2,500, count 4, $2,500. Said count 5, $500, and count 6,
$150. Thank you, Your Honor.
All right. I found probable cause. I've set bond. Good luck to you, sir. Again, your case will be coming up If they choose to file in court and the division judge, you can make your argument for suppression of evidence and make those arguments in front of the division judge. Thank you. And good luck.